Okay, let's get started again. Welcome back. It's all going to be about neutrals. I was asked, are neutrals the same as mediators? Neutrals are sort of the overarching label for mediators and arbitrators and early neutral evaluators, all of those different kinds of people who do ADR. So a lot of what we're talking about today will be about mediators in particular, especially when we get down to peer review. But it's my understanding that you're thinking about various kinds of ADR approaches, so we're not only going to talk about mediators. Let's see. Okay. I don't see anybody new, right? So we don't need to talk about why we're here. But since you were here this morning, any lingering questions from there that you just want to talk about right now, or shall we just jump into the first session this afternoon? We're jumping, okay. You've got a lot of cool materials in your packet. We're going to talk about this peer review stuff at the end of this session. So let's be sure we've got at least 15 minutes to talk about that before we're done, and this goes to 2:45. So by like 2:30, we want to be sure we're over talking about mediation. About peer review. All right. Why do we care about quality neutrals? Angela, you look like, why are you asking such a stupid question? Of course we do. Right. What's the point if you don't have good neutrals, right? You've heard me talking a lot today about how you get systems in and and I'll talk about tracking and monitoring and all the rest of that. But when it comes right down to it, if the person who's sitting there at the table with the parties isn't doing a good job, it doesn't really matter what the rest of your system is, right? So the quality of the neutrals is really the linchpin in this operation. So how do you get them? And we're going to go through these sections: recruitment and selection, training and orientation, ongoing support, monitoring, which could be both surveys and statistics, and assessments and grievance procedures. So, in case you were wondering if we'd have anything to talk about this afternoon, let's talk about, I'm going to talk about first the characteristics of programs with quality neutrals, and then I'm going to talk a little bit about the characteristics of quality neutrals. They select people for their roster fairly. Now, I'm using the term roster here. We'll talk, after these two slides, we'll talk more about what a roster is. It's basically the people who are going to be providing ADR services. But you've got to pick them in a way that is fair, right? That people don't feel like they're either being excluded, or that that's about it, that they're being excluded. Your program also needs to appoint the neutrals to cases fairly. This can go wrong at least two different ways. What you don't want is mediators in the back halls by the chambers chit-chatting with the judges and saying, oh, don't forget to refer that case this afternoon to me, right? So you need to not be sort of pressuring not having neutrals pressure to get business. But what I've also seen is the opposite, where you have a court that has a pro bono element, so most of the services are provided at market rate or on a sliding fee, but for some people, they're really pro bono cases. And I've seen this with family judges in one circuit, which will remain nameless, where the really helpful lawyers who were also mediators were in court, and the judge would say, oh, you'll go mediate this case for me, right? So these people who were sort of the nicest people got the most non-paying work. So you've got to figure out how to be fair in how cases get assigned. Compensates neutrals fairly. Whew. There's I don't think that that excludes necessarily having volunteer or pro bono rosters of mediators, because there are lots of reasons that people want to mediate. But you also don't want to, be taking advantage of people or having the court neutrals be seen as not as qualified or as competent as the sort of private neutrals. A good program provides ongoing support to their mediators or neutrals. And, that may be, like I was saying earlier, the pizza lunch or what have you, continuing legal education. Your program also needs to have a way for the participants to complain about the services. There are some courts that have, some states that have really gone all out to create kind of grievance processes. Some leave it more to, if somebody has a problem, they should approach, the judge at X level, the presiding judge of whatever, or the chief judge of whatever. But when you do that, you also need to have due process elements in there for the mediators, right? So if somebody is complaining, that mediator, who may have done a fine job, needs to have some ways to sort of represent his or her position in that process. And then a good program also monitors and assesses their mediators fairly. Okay, how hard could that be? Now, characteristics of quality neutrals. Well, first of all, they need to have the right skills and knowledge. And those are two big sweeping words, right? Skills could be all about everything from active listening to reality testing to helping people figure out what their needs and interests are and how the options they're developing relate to those needs and interests. And knowledge could be anywhere from knowledge of how the ADR process works to substantive knowledge. I know that the more I know about a particular area as a mediator, I typically rely on my skills as a mediator, not my substantive knowledge. But what I've found over the years is the more I know about a particular area, the better I feel like I'm mediating. When I started mediating foreclosure cases, I kind of had an idea about how it all worked. But once I had sat through, and worked through several of them, I was like, oh, okay, these are sort of the typical bumps in the road, and this is what people often say. And so, the more kind of that knowledge might come from experience in mediation or from other kinds of experience. You want your neutrals to operate in an ethical manner. We have tons of resources on ethics. The place that I would start with, though, are the model standards of conduct for mediators that were developed by the AAA, American Bar Association, and Association for Conflict Resolution, most recently in, I think, 2005. They are a very overarching set of standards that can help you think about what it is that you really want to expect from your mediators in terms of their ethics. David's going to spend a lot of time talking about ethics tomorrow, so I'm not going any farther with that right now. But not understanding the underlying ethics of an ADR process can be troublesome when if the people who are administering that process are most familiar with either legal or judicial ethics, and they don't necessarily know the nuances of mediation ethics, it can be much more difficult to draw some appropriate and distinct lines. So go hear David talk about mediation ethics. And if you're interested in other kinds of ethics, there are ethics for early neutral evaluators, for child protection mediators, for family media. There are a lot of ethics out there, and you can get to them from our website, from our resource center. they meet the parties' reasonable expectations. That's supposed to have reasonable in there. If the parties show up, they expect somebody who is coherent and organized and can help them, reach an agreement. So there's some reasonable expectations that the parties have. They share, the mediators or the neutrals within a program share a common understanding of the process that they're providing. For those of you who are really familiar with mediation, you know that there are lots of different processes that we think of as mediation. And some of us have very strong camps about, oh, if I'm over here in this camp and you're saying you're doing that as a mediator, I don't really think you're mediating. Setting all that aside, you want to be sure that the mediators within your program have a pretty uniform idea about what mediation is. On things like how long are you going to be in mediation and how much is the mediator, if at all, going to make any suggestions. You want to be sure, especially when the court is appointing or naming a mediator, that the court knows what that product is that's going to be delivered, right? If I just walk out the door and I want to go hire a mediator, nobody really has responsibility. It's on me as a private citizen to hire a private citizen. But if I go to the court and the court says, oh yeah, either I want you to go work with so-and-so or pick from this list of mediators, then the court's got some responsibility that those people are going to work within their ethics, and that the court has an idea about what that mediation or other ADR process is going to be. Make sense? I think I got a little redundant here because I think this next bullet kind of says the same thing, right? That you want it to be a sufficiently uniform manner in which the services are provided. Now, when I say words like uniform, I am not saying that no two mediators are going to deal with the same case the same way. I'm not expecting that at all. It's much more sort of the broad brush outlines of how your ADR process works. And then this one, interact with the program in a business-like manner. This just comes from hard experience of having a mediator who says that they're going to show up for a case and then cancels at the last minute, or treats the frontline program staff disrespectfully, whatever. You want to be sure that the neutrals are interacting with your program in a reasonable way. Okay, quick chat. And really, this is just for like a minute or two, and I'm going to bring you back together. Do you know what you're planning to do in terms of who your neutrals are going to be, what you're going to do with them? We're going to talk about this more, and then we're going to circle back around in a few minutes. So just put your heads together really quickly and see if you're on sort of the same page. Okay, so maybe you've already figured this all out. You know exactly what you're going to do with your mediators, who they should be, or your neutrals. But assuming maybe that's not the case, so I'm going to talk first about roster models, right? I said a few minutes ago there are different kinds of rosters. The court may have a roster where they have approved certain people to mediate on their behalf. Some places call this certification. Do you use the term certification in New Mexico? Some are saying yes, some are saying no. It's a tricky word because it does not translate, at least from state to state, and it sounds like here maybe even from jurisdiction to jurisdiction. So I don't use it. I talk about sort of who is approved to be on the roster. So if the court's maintaining that roster, they've got to have people apply and review them and be sure that they're still on the roster. You know, they've got that responsibility. But the good thing is it gives the court more control, right? The judges say whether or not you're on the roster or not. Some courts, for their roster, contract with a third party. It might be a bar association, community mediation program, a company, a university or law school. So the court sort of, they may not contract, but they have a relationship where somebody else is providing these services. I think the biggest thing from the court perspective is you've got to be sure that you really trust your partner. And figure out what you're going to do in terms of maintaining that relationship so that the court feels like they still feel like they're getting the services that their litigants are getting the services that the court thinks they should. Another option is court staff, right? You can either have, in the Circuit Court of Cook County in Chicago, they have 24 or more full-time paid staff family mediators. And all mediation is free. They've got a ton of resources. That's how they have chosen to do. Now, mediation of non-financial child-related issues. You can get free mediation from staff mediators. So that's sort of the most inside the court. Sometimes, sounds like you all have a system where you have court lawyers, what are you called? Staff attorneys. Whatever, I found out he started on Monday, so I'm going to ask him all the time, what's your job title?
Associate attorney.
So you may have somebody who can wear a couple of different hats, right? Tricky, because then are the parties going to feel like what they talk about with that staff attorney, thank you. With that staff attorney is really confidential, that staff attorney who's sitting back there where the judges and other people are, that what you say to that person isn't somehow going to end up with the judges knowing it. But the point is that there are lots of different ways to do this. And the resources, the human resources, financial resources in your particular jurisdiction, how densely or sparsely populate, all of those things, maybe someday I'll be able to figure out the algorithm for it, right? Where you've got the right X and the Y that all turns out to here's what your mediation program should be. But right now you're going to have to figure that out for each program. So what should the qualifications be? I don't think and I talked about this a minute ago. The skills, right? Satisfy the reasonable expectations of the parties, function ethically, possess necessary knowledge. Now, what I've seen is that sometimes in courts, because you're operating within the law, you highly value the knowledge of the law as compared to some of the other factors that could go into being a good mediator. And that may or may not be a useful factor, or the amount of legal knowledge that you need may vary. So think about these in a balanced way. The skills, the expectations, the ethics, and the knowledge should balance each other out. You don't want to get too heavy on any one of them. The way that I often say this with some judges who are considering having sort of lawyer-only rosters is, if you have somebody who's been a family mediator for 15 years, is that person really all that much more qualified to come do large civil mediation cases? Being a lawyer, even an experienced lawyer, is not necessarily the thing that is going to give you that substantive knowledge that's going to be helpful. It may, but not always.
On the roster model, it seems like one of the difficulties is who pays what, when, to whom. So we have some courts that have a roster, but then they send people to that person, and then that person, has a fee, and they pay that fee directly to the mediator, and then they agree to do some free ones. So if the judge says this is a pro bono case, then that's part of their mix.
Very typical.
But
Right.
then you have sliding fee scales where the money can go to the courts, and the court collects the fee and then assigns them to somebody on the roster or a staff person, and then you have better access to justice principles, I believe, in that kind of a context, because you don't have, you know, fees being paid to somebody else, and those fees may be something they can't afford. Whereas if you're paying it to the court can look at your income and determine the fee, but then they're paying their mediators. Can you comment on that?
Yeah. So one of the issues in what you've just talked about is how much the court wants to get involved with receiving money from the parties and paying it to the mediators. There are some courts that really shy away from having to do that. So that's just another factor that you're going to need to consider. In terms of like who's going to decide how much the payment should slide on that sliding fee scale, yeah, I know of at least one jurisdiction where most of the family mediators are therapist mediators as compared to lawyer or other kinds of backgrounds. And that happened because the therapists in town charged less per hour than the lawyers did, and so the parties tended to go to the therapists. But then the therapists just sort of on their own were deciding, you know, based on whatever conversation they had with people, how much they were going to slide their fees. And so, I mean, that really informal setup seems like it's fraught with possible problems. But the other side of that is how much is the court willing to take on the responsibility and that extra work.
In New Mexico, we do have sliding fee scales determined by the Supreme Court. So that was mandated by the legislature, and the Supreme Court took on that and did it. The difficulty comes where if the courts aren't collecting the fees, then that sliding fee scale doesn't apply because it's not under the court. So then you have conflicts there in terms of access to justice.
You do. The point I was trying to make was that even if it's the court that's making the decision, the court has to, you know, have a hearing or collect the information or whatever to decide where somebody should be on that sliding fee scale. So yes, sliding fee scales are great, but the more options you have, the more expensive things can be in terms of the time it takes to implement it. Yeah. Are you furrowing your brow over here, or are you just listening intently? All right. All right, so how are you going to recruit and select? Recruitment, you know, it can be an open call to the public. You know, you could send out announcements in targeted media, depending on, you know, who it is that you're looking for. One way that I have seen this done, and I'm putting it out with some sort of caveats, but that has worked, is to have the chief judge in a jurisdiction invite particular people to go through the training and become mediators, because if you do that, and those are these very well-respected professionals in the community, then the other professionals in the community are more likely to say, oh, well, Lucy's doing that, so this, you know, this has got to be good. I trust her. It does then lead to that other question of, so you're inviting some people and you're not inviting others, and so you can do a combination. I know when we created a program much more recently, there was a very broad invitation to people to apply to be on the roster, but then we asked the judge to, you know, figure out who are the half dozen people that you want to reach out to, and really ask them to be part of, and this was a volunteer roster. You know, ask them to be part of it because you know what they will bring to it in terms of kind of their reputation and their skill. So the way that you do your outreach, again, all this can be sort of fraught, but it also has an impact on who you end up with. Selection, the place I start is, if my sister was going through a mediation, who would I want to have her mediate her case? My sister works for a retirement company. She's an administrator in the office. She, other than hearing me yammer on about mediation over the years, she doesn't know about mediation. So who would I want her to have mediate her case, this case that doesn't exist? And the first thing I would want is somebody, of course, who's got mediation training. I would really prefer that it be somebody who has mediation experience, right? Don't go learn on my sister. I would want it to be in the type of case that she has. And I would want it to be in a way that I thought was the right way to mediate. And I would like that person, that mediator, to have some substantive experience or knowledge about the kind of case that she is dealing with. So that's kind of where I start from, is like, what's the model mediator? And then I go to reality, because when we're doing foreclosure cases, who knew? Because there you're trying to find somebody who understood banking and who knew how to mediate. Even in the city of Chicago, there were not a whole lot of people who wanted to do that, or who were capable of doing that. So then I have some sort of a mixture of training and experience. So maybe somebody is very experienced in an area, but they've just gotten their mediation training, or maybe they've got a lot of mediation experience, but they've just gone through a course to really understand what the substantive area is. You're sort of mixing and matching. So, yep, that's kind of how I think about who I would be looking for as a mediator. Do you have state law about what constitutes mediation training for people in court? Okay. So the standard that has just evolved over the last few decades is 40 hours of mediation training. There's nothing magical to that number. I've seen very few people really be ready to mediate at the end of 40 hours, but that's sort of what we're used to. I think a big question is what happens in the mediation training, right? So how much is it that the trainer is educating people about negotiation and conflict and the theory of how people come to resolution? How much is it that they're having exercises to work on, listening and generating options and all that? And how much do they get to practice? Because we adult learners would much rather sit around and talk about something than actually try and do it. And so you kind of have to push people to be in simulations. But then once you're in the simulation, do you have somebody there who's knowledgeable, who's watching you and is saying, no. When you just did that, did you see what your parties did? I really value that personalized feedback as people are doing simulations. So I get people who call me all the time saying, I want to go through mediation training. Which one do you recommend? And so I go through, here are the characteristics that I would suggest, rather than necessarily sending them to a particular training. But you may then, if you as a court, you may say, we're going to conduct training, and anybody who goes through that training, we will then select our mediators from the people who have completed that training. I know, when we've conducted programs, we've just had a couple clunkers in there where no, this person just sat through that whole training and they just should not be set free to mediate with people. And then especially if this is somebody the chief judge invited, you've got to figure out how to work your way around to saying, no, this person should not be on this roster. So you may do a training where you provide it in exchange for people agreeing to mediate for you. I don't know that there's much more to say about right now. I mean, we could talk the rest of the day about what mediation training should be like, but the other piece that sometimes gets missed is the orientation, right? Getting those individuals to understand in a particular type of, If you're in small claims court, okay, so you're going to show up every other Wednesday at 9:30, and this is where you sit in the courtroom, and here's where you get the file, and here's, and here's the form that you fill out at the end, and here's how you get people to fill out their surveys, and you've got orientation that you've got to do with people too. And then the continuing education that may be on specific topics, or that may be about particular types of cases or what have you. And that relates to retention. For some people, the continuing ed is a great benefit. It sounds like you've got mandatory continuing ed here, so free CLE credits, if that's what you call them, can be a nice benefit to offer people. Gathering people for continuing ed is also a way that you develop the community. We were talking this morning about sort of what's the culture of mediation or ADR. Well, being a mediator is a pretty solid, you operate in solitude when you're a mediator, right? You're in there, you're with the parties, but you're not really talking with other people, and you're not really supposed to leave there and talk with people about what just happened in your mediation because it's confidential. So if you as a program bring people together and they have an opportunity to talk with other like-minded people, it kind of helps develop that, that sense of an ADR community. There are two tools that are that I want to point out to you. So one place to go is the National Standards for Court-Connected Mediation Programs. These were written like in the 90s and are still remarkably good today. So that's more about your program overall. And then the other is you have a little introductory page about model surveys in your packet. But there are these surveys that you can adapt to use to give to your, use with your parties. RSI and the American Bar Association Dispute Resolution Section spent a lot of time creating model surveys. We tested them with people. And we have not only the surveys, but also instructions about how to use them. In your materials, you have the first little section on it is D, RSI ABA Model Mediation Standards. All right, I'm not finding it in here, but you, yeah.
It's like the second to last of the peak.
Second to the
As
last.
in front of the orders.
Okay. Well, so it's in here. And as you can see, there's a ton of information in here where it has the surveys to give to the parties, it has the questions to ask, it has the explanation for why particular questions are asked the way they are, has instructions for how to adapt those surveys if you want to do them differently. It also has mediator surveys and mediator reports that we keep separate. The mediator reports are the things that go back to the court that say whether or not the case settled and that sort of objective information. You may have some mediator surveys that the program wants that are more about any particular issues that the mediator encountered or what have you. If you want to find this, the other way to do it is, I think at the very beginning of your materials, like after the second pink page, you've got selected resources for court ADR programs. And it has the addresses for the national standards, for the model standards of conduct, and those mediation efficacy studies we talked about earlier. So there's, and that's very early on in your materials. It's right before you get to the beginning of the chapters. So I would suggest that you go there and dig deep into it. Okay, payment. We've been talking about this already because it's such so much on the minds of those of you who are here. I mean, you can start with those who can pay, right? And so there may be some substantial amount of proportion of the cases that you want to send to mediation or ADR where the parties are capable of paying for it. Then you've got the sliding fee schedule. But then the other question is, well, how much are you going to pay? Are you going to pay market rates? So what's the market in your area? And if you are someplace where there are no mediators, what's the market there? And if you're in a place that has mostly sort of the private mediators, is the market rate for them the same as what you want to be paying? There's a lot of math that has to go on. And part of it just boils down to, from the court's perspective, how little can we pay and still get really quality mediators, right? I mean, the court is looking not to support the careers of mediators, but rather figure out how to serve the needs of people. So you can do market rates, you can do below market rates, sort of the low bono approach. You might just be paying them a stipend or some sort of a payment for parking or travel, or you may have people who are purely volunteers. That is something you really are going to have to figure out in terms of your own jurisdiction, and who the people are and what you think they're going to be willing to pay. It isn't like there's some magic answer that I have that says this is, you should pay everybody $300 an hour. We talked a little bit earlier about the court's role in processing the payments. One other question for the court is, are you paying per case, per session, per hour? Right? Courts, understandably, want to have a predictable amount that they're paying. So courts typically want to pay per case. At least that's what I've seen, or per hour up to a certain number of hours. You're going to need to figure, how many times am I going to say that today, you suppose? You're going to need to figure out in your jurisdiction how this is really going to work. But you are. I'm just saying those are some of the options that you have. You also, Judge was talking a minute ago about, does the court take in the money and then pay out the mediators? Or, another option is that you have some outside third party who is making some determination about the ability to pay, and then, taking money from the. There are lots of different ways to do this, and how you decide to do that is going to depend on factors like, do you have a partner locally who could even deal with that for you? Or, because if you don't, then that's not an option. Within your court, do you have the staff who can deal with the requests for sliding fees and figuring out where it should slide to and receiving payments and making payments? Somebody's going to have to do this work, and the question is who's going to do it. Okay, we're still on payment. I think there's something beautiful about volunteer mediators. I started as a volunteer. I still really respect volunteer mediators. It has changed radically from when, there weren't careers as mediators when I started as a volunteer. And so people who were mediating then were doing it really just as a volunteer in their community. Now, a lot of people want to get the training and get the experience because they want to be able to market themselves as mediators who get paid out there in the world. So I still think you get a lot from the volunteer mediator experience in terms of the building the community and training people that then take those skills out into their community and use them in other ways. There's some downsides, right? You've got to support them more. You need to really establish a culture of professionalism among the mediators, so that people say, well, you're either a professional or you're a volunteer. No, you need your volunteers to be very professional in when they sign up and that they show up, and that this isn't something that you just sort of do if you want to do it, and if you don't, you wake up and you don't feel like going to small claims court that morning, you just don't go. So there's a whole culture that you have to establish and maintain. And two things. One is, just because they're volunteer mediators doesn't mean they're free, right, because of all this support. And you also are probably going to be excluding people who don't have the resources to be able to just spend their time volunteering to do something. So there are pros and cons, and I just, in my heart, I really love the volunteer mediators. Now, how do you assign mediators to cases? There are probably 3 or 4 different ways. One that courts talk about is by a wheel, which just kind of means you're the next one up whose name comes up, and so here's a case, it's your turn, you mediate it. So it's very random. Now which is good, right? It's fair if you have everybody on your wheel are all capable of providing the same high quality services, then you should be able to, whoever comes up next, you'll go do this mediation and it'll be just fine. What you don't get is any ability to sort of matchmake and say, oh, we've got these mediators over here, or these two, who just have a ton of experience with construction, and this happens to be a construction case, but the person with that, their name isn't the one that they did a case last week. So that's the downside of the wheel. And you still have to check into the potential conflicts of interest even once the wheel has stopped, right? The mediator and the parties have to have a chance to do that. You can have sort of the wheel and have the staff involved in helping to pick who might be good for particular cases. You definitely want to keep the judges away from appointing mediators, because David, you're looking at me like I'm crazy. Because what you don't want is a judge looking like they're saying, oh yeah, that's my friend, go hire him to mediate your, oh, you got this really expensive case that's going to last for months and you can pay him $1,000 an hour, go hire Brendan, right? You don't want your judges in that position. And the reason I talk about sort of this staff and the wheel is that then you can also factor into that the sliding fee and the pro bono cases. So that somebody, the wheel doesn't spin and every time it comes up with Sally's name, like, oh, congratulations, you've got the pro bono case again. You want to balance that out. Monitoring and assessment. We're going to talk about peer review in a few minutes. You do want to have some sort of complaint process, which is a lot harder than it sounds. At least it can be, because you need to figure out what you expect of your neutrals. And it's a confidential setting. Neutrals work differently. They have different styles. You expect that. coming up with like a description of what would be outside of that is very challenging. There are states like Florida that has probably the most robust state court ADR program, and they don't just have ethics, they've got a whole disciplinary code. And it explains exactly what a mediator should do and exactly how somebody can complain about them, and then what the rights are that the mediator has. I mean, that works because Florida is so completely into using mediation that they can support this whole big structure, but you don't start there. But the other thing with that, two other things. One is, what are the ethical standards that you're expecting? And you have to decide who has the final say, which is probably your chief judge, or whatever your term is for the person who's at the top of the heap in your particular jurisdiction. That's probably the person who is going to have this authority/responsibility. And the further they are away from the mediation program, the trickier that's going to be, because they may not understand all of what's going on. You know, if you're over in, you know, you're the chief judge and you've been in criminal court your whole career, and then you've got this whole thing about confidentiality and a complaint, and it can be hard to figure that out. Okay. Yep.
I noticed that when you've talked about, a few times you've talked about monitoring or assessment about mediators, that you're talking about complaints coming from parties. And a lot of times parties don't know what the heck mediation is. They
Yep.
wouldn't know a good mediator from a bad mediator, but they'll know if they feel terrible at the end of a mediation. I'm just wondering, you know, there's got to be another kind of monitoring and assessment going on that's not the parties.
Yes, I totally agree, and I think there are two other aspects to that. I feel like you just teed this up for me. Thank you, Sally. One is these surveys, right? So if you ask people, did you feel like you were, you had a voice? Did you feel like you could talk about the issues that were important to you? And you know, every time you get back, Isabel's surveys, they say, nope, I didn't get a chance to talk, and no, then you're thinking, okay, maybe we should go talk to Isabel about what's going on over here. Now, if you've got one, you know, that's just sort of ranting about how horrible the whole thing is, you might want to go say, Isabel, that sounds like that was horrible, rather than, so the surveys are one way to do it, but understanding that you also are going to have a lot of people where literacy is an issue as well. The other piece that I think we're going to talk about peer review, actually. We could talk about it now. We have time. Is you develop a peer review system. Does anybody have a peer review process in your mediation or arbitration program? They're rare. They don't happen all that often. Nope.
With children's court mediation, we have our mediators observe, we have new mediators observe, and we have senior mediators sit with them and kind of give some assessment on how they react to the cases, because we deal with very emotional cases.
These are children who are in the state welfare system? Yeah, I mean, that's exactly the kind of thing I'm talking about. I'm talking about it a little more bureaucratized than that. And I know somewhere in your materials we've got, oh yeah, I think it's actually right after one of the pink pages. You've got a whole section on model tools for peer review, where we give you model tools. So you do it for 3 reasons, and I'll talk in a minute about what I mean by it. You want quality of the services, right? I mean, like I was saying before, mediators are operating in isolation. Nobody's observing them, and so you want to be sure that everything is still going right. You want mediators to improve, right? And how do you do that? Well, you have somebody give them some feedback. And you want to develop the mediator community, And so observing one another, talking together afterwards, that can accomplish that. So there are 3 foundational documents. First is your peer review policy, right? You want to be able to write up, this is how this is all going to work. Let me stop for a minute, and again, like I keep saying it without defining what it is. Mediation peer review, as I have experienced it, you have more senior experienced mediators who together agree on and within the program about what the model of mediation is that you're expecting, right? We were talking earlier about sort of it being a uniform model, understanding that there are different styles. And then a senior mediator goes and observes another mediator. They may just be one class junior, right? You sort of start and work your way down because you want to develop a whole cadre of people who can be peer reviewers and observe one another. So if I'm mediating, I have Cassandra. Do you go by Cassandra? Cassandra is my senior here. She has been mediating much longer than me. She comes and she's going to sit in the back corner of the room. During my opening, I'm going to explain to the parties, not that I'm being rated, but rather, we have somebody here who's studying mediation and she's going to be observing. She'll be under the same requirements in terms of confidentiality, et cetera, and be sure that people don't have a problem with that. Cassandra observes. If I am going off to caucus with people, she shadows me. She doesn't say anything. She just, wherever I go, Cassandra goes. When the parties are done and they leave, Cassandra and I sit and talk. You may structure the program so that Cassandra has the authority to say either like, oh man, that was great, or oh, what were you thinking, or you need this training, or what have you. Or what you may have is, once you've sort of got your cadre of mediators and your community, you may have a, excuse me, a peer review committee. So Cassandra's going to talk with me about, boy, it seemed really hard when you did that. We're going to debrief it together. But then Cassandra's going to go back to that committee and say, you know what, here's what I observed. I think she's okay. We talked a little bit about this, and she now understands that was, she could have done it better that way. But I think she's fine. Or, oh my gosh, from the very beginning, a peer reviewer was never supposed to jump in, but I really wanted to jump in. So the committee then decides what should be the determination as to whether or not I should just keep mediating, whether or not I need some extra help. Or whether or not I really should just not be mediating anymore. One of the benefits to a court in having a peer review committee is that this judge, who's going to be the final say about whether or not mediators continue to mediate, is getting information from a whole group. It isn't just that somebody has come and complained or whatever, and then the judge is deciding, oh, well, you just can't mediate anymore. It's a much more established process. One of the tricky things, though, is figuring out what those parameters of the mediation are, like what is acceptable and what is not, and what is just like, oh, I just didn't really think it was important to do that right then, and it's sort of personal preference as compared to they were ranting and upset and crying, and you never said anything about their emotions, and that's part of what we expect in the way that we do mediation in this world. So that's a quick overview of kind of how peer review can work. In here you have a model policy. We developed this for our child protection mediation program, and then adapted it to make it a little more universally applicable. So it's got the goals, it's got the procedure, and when we started in this child protection program, we had our staff person, who is a really experienced senior wise mediator do the initial peer reviews. And he would sit and talk with people, and then as he felt that the people who were really got it, he would sort of talk with them about how to peer review and train the next little cadre of people who could review. This can, how many times today have I said this can be tricky? But it can be tricky because what happens is if you've got a big roster of mediators, you end up, instead of, your goal would be that everybody gets observed once a year, right? They get feedback, it's a community building thing. But you don't, you don't end up being able to do that. And so you kind of shrink and you end up saying like, we have some worries about so-and-so. Let's go be sure that Susan gets observed next. And so it can lose some of the sense of community building and instead have it feel a little more judgy, and not in a judge-like way, judgmental. Yeah. Is this whole, what are you thinking about peer review? You think you wish you had more caffeine at lunch, or?
I'm thinking that it is incredibly hard for mediators to be reviewed, to have peer review, to have someone watching them, to have someone saying, even when I think it's fairly well known that there's somebody with, what it really calls for is someone accepting the fact that someone with lots of experience has anything to say to somebody who doesn't have experience. And that's not always true.
Yeah.
And so
It's not always true that the person has anything to say or that the person has anything to hear.
Who is hearing it thinks anything about it. That why are you sitting here telling me how I'm doing? And it's not telling them how they're doing, but that's how they perceive it. And the whole notion that they're being evaluated. Already just stated, mediators just quake in their boots about evaluation. Oh my God, I'm being evaluated. Now, I think self-reflection is an incredibly important part, and frankly, for me, if I'm worried about a mediator and their skills and abilities, I'll have them self-reflect, and that's going to tell me a lot about whether or not they even have it on their radar that there's something that they could possibly improve with.
So you would not have seen them mediate, but your antennae are up that there's a concern about this individual? And
Yeah, or that another mediator who's worked in a co-mediation model who's worked with them says, help, do something about this.
Yeah. Well, and peer review really does both support and demand a particular culture. It's not like when we started our child protection program, we said, this is what we're going to do. And so sort of the mediators who grew up in that program knew that this was what was happening. And when they were first mediating, they were really grateful to have this wise staff person just debrief with them, right? Because for those of you who are mediators, you walk out and your head's about to explode about what you just saw sometimes, or you're exhausted or whatever, right? And to have somebody who just saw it all. I love having like a student who's learning about mediation shadow me, because then afterwards I'm like, what did you think when they said this? Which you don't have otherwise, right? Some people will accept it and value it and others will not. And then the question is, how much of it are you doing as a way to address the mediators where you feel like you're going eek? And how much of it is that you're just trying to develop stronger mediators? Right, yeah. And it's, the people who are already strong probably are going to be fine about, they'll either like take the feedback or they won't. The people who are weak are the ones probably who are more likely to say like, oh, you don't know what you're talking about. I've known this lawyer for 40 years and that's just, you've got to handle him this way. But that's going to tell you more too, right?
Do you have any experience with peer review, mediator observation, all that?
coaching, counseling by video rather than in the room in the presence of the mediation?
No. Are you, the first thought that comes to mind is if you're actually taping it, then you've got all these confidentiality concerns. So
Or if the peer reviewer, mediator,
Distance?
observer is at distance, doing it through closed circuit TV?
I don't have any experience with that. I think, if you're trying to figure out this very far-flung, reaching all of the most sparsely populated counties, you may end up getting there. Going back to what I want my sister to do this, I don't know that if I didn't already have a high level of trust, I would trust that whatever was being watched was going to the right eyes. So I don't know quite how I would personally feel about that. A little paranoia. Other thoughts about peer review? Nope. So in your materials, you have a mediation observation form. To this day, when I'm watching somebody learn to mediate or I'm observing them for some other reason, I want to have this checklist in front of me to sort of prompt me and remind me about things that I should be looking for. I think that a document like this can be really handy for mediators to say, look, here's sort of what we're aiming for. That whole sense of getting onto the same page. Now, you can have people who are very by the book, who are like, if it isn't in here, then I shouldn't be doing it. Like, no, this is just a sketchy overview. The one thing I do not do is fill this in and then share it with anybody, because I need to be able to write on here, like, they said what? I have little stars and arrows and big question marks and stuff. So it is, it's the next to the last pink page. You have that, and then a few pages into it, you have this form. Yeah. And even developing a form like this is another way to bring your community together and have them think about what mediation really means to them. I think that's, let's see if there's anything else. Then the self-reflection tool, which we have one in here. The state of Virginia has an amazing self-reflection tool. Okay, so the self-reflection tool comes after the mediation observation form in the peer review materials. And it's just a little two-pager. Your program could do it on 2 sides of 1 piece of paper, and it just prompts people with a list of areas like guiding the mediation process, using separate and joint sessions effectively, reflecting and working with them, just a little checklist of items to go through and say, oh yeah, I did that. Oh yeah, no. Particularly well, what you would do differently. What did the parties need from you? When I leave a mediation, and I'm tired, and we might have reached agreement, maybe we didn't. The question I ask myself is, were these parties well served? And usually, I can say to myself, yeah, but there's always something where I'm thinking, if I had really heard that issue earlier on, we wouldn't have taken as much time getting to where we got to, or what have you. So in sort of my self-reflection, that's the question which is why then it gets reflected in here in sort of another way of what did the parties need. And then, if it was peer-reviewed, what was helpful or not helpful about your debrief with your observer. So everything can kind of flow together, right? Yeah.
Did you say like that this would be a useful tool sort of as an alternative to peer review to figure out from the mediator how they're doing? Could you talk about that a little bit more? Because when I look at this form, it looks like it's just for the mediator to fill out and use for their personal use, not to share with anybody.
I think, Sally, you said that you asked people to sort of reflect, and do you have a format that you use for that?
It's the best practices that were developed somewhere in New Mexico, mediator best practices, and it's pretty detailed. Does the same thing, just asks folks to go through it and assess how they're doing.
And then do they share that with you? And you talk to them about
They
it?
do
or-
share that with me.
Okay.
Yeah. And periodically, that's one of the ways that for me, I can tell if I have sort of a sense of how a mediator's doing from, say, an observation, and then I have them do the self-reflection and I check that against what I saw, it can be really helpful.
And I am going to go.
So Virginia, they have this, I think it's just amazing, this mediator self-reflection treasury. So it's got some good introductory stuff, and then it has these sections like the keys to the kingdom and consider the mediation principles listed below. How do they strike you? And I just love this thing. It's got a lot of white space to it. It's got a lot, it's not long, texty descriptions, but there's just a lot of real quality in there. So if you're looking for a mediator self-reflection tool, I think we should take a break. I think it's early, right? We think we're supposed to go for another 15 minutes, but I'm having the feeling that you all need to move around a little bit. Is this true? So I don't know, should we come back in 15 minutes or should we wait and start at the regular time? What's your pleasure, Mateo? Okay, so come back at like 2:45 and we will, right? Yeah? Go, move, circulate your blood.